So let's get started. And for this part, I warmly welcome our three panelists. This is Mary Lawlor, the UN Special Rapporteur on Human Rights Defenders, Professor Violeta Moreno-Lax, who has written an impact assessment on the EU's Commission proposal for a new facilitation directive, and Julia Winkler from Decriminalize, a group of activists supporting people on the move that face criminal charges because of supposed smuggling activities. Dear Mary, dear Violetta, and dear Julia, we are very honored to have you with us. Thanks for your participation. And I want to start with you, Julia. So we just listened to this statement of Haruna, to his testimony. His criminalization is not a single case. To the contrary, many people on the move in Italy, in Greece, and other countries are facing similar charges. And Decriminalize is supporting many of them. Can you explain us how this criminalization works and how it is linked to the old Facilitation Directive?
Yeah. Hello, everyone. Also, thank you for the invitation. And yeah, we'll go straight forward to the question since we don't have too much time. Yes, also, thank you for giving the space to the criminalization of people on the move in particular, since yeah, they are the ones by far most affected by it. So in terms of quantity, like numbers, but also in terms of severity of the charges, but it receives much less attention. And in reality, it looks like that, yeah, due to the very broad EU legal framework, that in reality, then also the national legal frameworks are generally framed very broadly and also like essential safeguards that this results in people being criminalized for like, yeah, quote unquote, facilitating their own entry, which means basically like simply for migrating. And also, what Dorothy mentioned earlier, it's also like then the ones who basically take on a more active part during the journey, maybe more than others. And then we have this dichotomy of suddenly then they are the bad ones, they are the smugglers. And so to avoid criminalization, you have to be passive and yeah, which I thought was a very interesting aspect of it as well, Doro. And yeah, we already mentioned the Kinzer case that Karen mentioned in the beginning, and I think most of you are familiar with it. And there is a great website, so I might not dwell into it in too much detail. But yeah, just to summarize, this was a mother coming with her minor child and niece in order to seek asylum in Italy, and was then separated and charged with facilitation of unauthorized entry for the two minors as well, facing 5 years in prison. But yeah, luckily now the European Court of Justice ruled that this was unlawful. But yeah, the situation where the criminalization occurs a lot, or maybe even the most, is the criminalization practice of criminalizing boat driving or taking on any other role on board. And we even think they maybe make up most likely the majority of all smuggling related charges in the whole of Europe. And that's also why we really need to focus on it and mention it more. Because, for example, in Spain, UNODC found that anti-smuggling investigations usually focus on boat drivers. In Italy, we have the numbers that it's like been more than 3,000 people in the past years that have been charged in connection with driving the boat. And in Greece, we also have the numbers that they are most likely the biggest group of all people being arrested and convicted for smuggling there. And if you look at the example of Greece, that also gives a very clear example of how practical implementation looks like when you have a very broad legal framework. Because if we take this example, there's legislation under which under which people that are arrested for boat driving are charged is defined simply by unauthorized transportation, and it carries a penalty for each transported person. This is also why we have in Greece often like these very crazy big numbers, because if you have 50 people on board, then of course it gets multiplied by 50. And acting for profit there, for example, is considered only an aggravating circumstance, which only increases the penalty. And this is also not clearly defined what profit means, which I also will maybe when we talk about the demands more clearly. And in practice, this leads to the situation that literally any act on board can qualify as the offense. So we had cases in court where people were charged because they used the GPS, because they were distributing water, because they made an emergency call. And this was always enough to be found guilty, maybe just as an accomplice, but still be found guilty and also to receive a very severe sentence. And with Borderline Europe, we also did a study where we documented more than 80 such trials. And also in none of them, additional evidence was presented that somehow would argue that this person is a smuggler rather than a regular passenger. But it was always just focused on evidence that identified the defendant as the driver, and which also shows that investigation either stops after they found the driver, or even if it goes further, it's not presented in court, which means it's deemed irrelevant. And really just the act of driving is in the focus. And this is also, irrespective of if the person was part of the group, if the person asked for asylum, if the person stated that they have been coerced and maybe then actually qualifies potentially as a victim of human trafficking. And it leads, of course, to extremely quick trials, on average 30 minutes. The shortest one we documented was as short as 6 minutes. And it clearly shows that if legislation is formulated like this and that broadly, that it inevitably, of course, enables the criminalization of people on the move in particular. And you could even say it mandates it. Like we also had cases where prosecution even said, well, we can clearly see you're not part of the smuggling group or network, but that's the law and we have to apply it.
Okay, Julia, thank you very much for giving these insights, and really also thank you very much for your work and the work of Decriminalize, because it gets not the attention it should get. Now, looking forward, we are discussing a new facilitation directive, and the Parliament is discussing it right now. So, what must change within this directive so that this form of criminalization is no longer taking place?
I picked a few examples which in this criminalization are quite relevant. I think, from when we look at the clear definition that we definitely need of the offense, what it's supposed to be, I think looking at the profit aspect is very important, because even though like there are discussions now to implement it, I think also the way it's formulated is really relevant, because in these cases we often have that people are being charged for having acted for profit because they steered the boat in return for a reduced price because they couldn't afford getting on the boat. That's why they did it. And then in Greece, this is being interpreted legally and used as having acted for profit. So I think if it's being integrated, it also has to be in a way that it's not vaguely defined. And also like these formulations we have like indirectly profiting or any other benefit. I think it also, when phrasing it, it has to really take into consideration that it's also being very clear that we look at undue profit, that we look at exploitation aspects. And then, of course, that as in line with international law, that smuggled migrants themselves are very clearly exempted from any sort of criminalization, and that also it must not violate also the obligations that member states have in terms of the Refugee Convention, because also what's important to mention is that a lot of the people that are being criminalized like this afterwards have no access to international protection anymore, because the conviction exempts them from seeking asylum, which I think is also really important to address. And I think in for these cases, that might be the two aspects I would like to focus on. And I think also what Doro said earlier before, that on the big picture, we also should not forget that smuggling in itself, if it's not done in a violent, exploitative way, it's also still a very necessary service. But maybe so far so good. And then I can.
Okay, thank you very much, Julia. And if you have any questions to Julia, please write them in the chat. We will collect them and try to answer them after the inputs of the two other panelists. So thanks again, Julia. And now we're moving to Violeta. Violeta, you are a professor of law, specialized on international and EU law. A few months ago, you did a quite impressive targeted impact, subsidied impact assessment for the European Parliament on the draft Facilitation Directive. Before we summarize try to summarize the 120 pages of your study, it's in a few minutes. Please tell us, what is this, a targeted substitute impact assessment?
Okay, thank you very much. I have just three slides because I thought it would be easier just to keep the time and to sort of do the task of summarizing what we need to summarize. So basically, a targeted substitute impact assessment is a document that does the work that the European Commission should have done, meaning a proper impact assessment, considering all the societal impacts that a piece of legislation that is being proposed is intended to have. Because the European Commission omitted this step, the European Parliament, in particular the Libe Committee, requested that that a targeted substitute impact assessment be conducted, in this case by me. Other times they can do it also internally by the European Parliamentary Research Service. And why do they do this? Because impact assessments are vital to support legislative work. Basically, they are vital for the co-legislators to take informed decisions, to provide reasons for those decisions, and thereby to honor the rights to good administration enshrined in Article 41 of the Charter of Fundamental Rights, to which we are all entitled. And this is very clear. It's stated in a 2016 interinstitutional agreement that the Commission, the Council, and the Parliament arrived at, making a specific commitment to better lawmaking. And yet, as I said, the European Commission did away with this requirement on grounds of urgency without providing very specific reasons, buttressing that urgency and using, at the end of the day, urgency as a blanket exception. This, however, is not satisfactory. The Court of Justice of the European Union, in constant case law, has underscored the significance of impact assessments as a very important step in the legislative process. And I'm quoting from a case that you see on the screen, which means that as a rule, these impact assessments must take place. And must is really an ambiguous language. And I would like to add that the absence of impact assessments in the past have led to the annulment of legislative acts on consideration that this omission impinges on the principles of proportionality and subsidiarity of EU action, including EU legislative action. And there is an example of a case launched by Lithuania and a number of other member states against the legislators for the omission of this impact assessment in these joint cases of 2020 that were decided in 2024.
Okay, thank you, Violeta. So it's already quite worrying, the approach the Commission is taking when drafting the new Facilitation Directive. But now coming to the content, is the content worrying as well? What is your assessment?
So in the study, I highlight, I think it's like 20 concerns, but here, for the purposes of brevity, I've highlighted what I think are the 7 most concerning of all concerns, some of which have already been put on the table by Julia and the message that we have heard. And it all boils down to the risk of over-criminalization, basically. I mean, it is an instrument that we really do not need. The reform is going to be making things even worse. So it is a regressive reform, and I'm not saying this on my own. I mean, I know that many other actors have been making the same point, but just for the sake of comprehensiveness, one of the main excuses, so to say, or reasons buttressing the reform has been the intention to align the EU acquis with the UN smuggling protocol and international standards, but this is precisely something that the reform will not achieve, because there are substantial misalignments between the definition of facilitation of irregular entry, stay, and residence versus the manner in which the crime of smuggling of migrants has been defined at the international level. And Julia already made this point, the lack of lucrative intent in all manifestations of the crime of facilitation of irregular migration is the most worrying trend. Also because there is further confusion that is generated by the new regulation of Europol that mentions migrant smuggling as if we had such a concept within the EU acquis. We don't. This concept is defined at the UN level. It is very specific, and it does include the need for a lucrative intent in the form of a financial benefit or other material benefit that has to entail some form of exploitative behavior and an intention to do so. All of this is not present in the current definition of the facilitation of irregular migration, which is the prevailing definition in the reform. This generates incoherence, not only vis-a-vis these other proposed amendments to the Europol regulation, but also vis-a-vis other EU law instruments. For example, there aren't any cross-references to the asylum acquis, and the right to seek asylum is absent from the text. So it might appear that asylum seekers that reach the European borders in an irregular fashion are committing a crime, which is not the correct interpretation under Article 31 of the Geneva Convention, which exonerates asylum seekers from any form of punishment, not only criminal, but any form of penalties, if they're doing so in search of international protection. The third concern is that the fundamental rights safeguards in the text are completely insufficient. There aren't any procedural safeguards at all. And the fundamental rights safeguards that there are contained within recitals in the preamble, meaning with no legally binding force and thereby not enforceable in a court of law. I mean, they could be incorporated by reference to the Charter of Fundamental Rights, but it would have been a much better legislative technique to incorporate them in the body of the text. The fourth concern is that there is no distinction between facilitation offences and the provision of services or humanitarian assistance. So service providers that might say, I don't know, give people a lift, taxi drivers, Uber drivers, for example, or people who are providing humanitarian assistance, clothing, shelter, water, you name it. All of these people can, under the terms proposed, be criminalized for facilitating irregular stay or irregular residence. The fifth concern, therefore, highlights this point. It is likely that many legitimate forms of service provision, as well as NGO and human rights defenders' activities, will be criminalized, if only because, for instance, the provisions on legal persons that can be targeted under the reform are those that have been legally incorporated, meaning those that have been legally constituted as legal persons. And this can only happen with duly conformed enterprises and NGOs. I mean, criminal networks do not normally incorporate themselves under any form of legal person. And so there are, I don't know, some implicit biases in the reforms that I think highlight risks for both service providers and NGOs that are particularly salient. Number 6, there is no proportionality in the penalty framework that the European Commission is proposing. The penalties that have been proposed are extremely high, also for behaviors that, if they wouldn't entail migrants, asylum seekers and refugees, would have no correspondence whatsoever in existing penal codes in the member states. And all of this, and this is the final concern, has a distinctive impact on civic space at the European Union level at large and the well-functioning of democracy within the European Union space, in the sense that there is going to be a chilling effect. Many, as you will know, are worried that there is this element of discretion, as we have heard in the video, that you are expected to assume if you do not want to attract too much attention for your activities and thereby risk criminalization. So this, I think, in a nutshell, boils down to one single concern, which is the concern of over-criminalization in a reform that was absolutely not necessary, that is going to be making matters worse. Because if we are going from a sort of voluntary exoneration clause in the current text from 2002, now we're moving to a situation where there isn't anything like that in the operative part of the text, and there are just two preambular provisions with no legally binding force in the new instrument. So this is going to generate doubts, it's going to generate unnecessary prosecutions, and thereby a chilling effect on humanitarian activity. I don't know if you would like, Andres, that I move to potential solutions.
Yeah, for sure. We need solutions.
Okay. I mean, I don't know if these are, again, anything that people would not be familiar with, but if you're going to be lobbying the European Parliament, I mean, I have one thing that corresponds to each of the problems that we have just highlighted in terms of pushing for the real full alignment with the UN smuggling protocol and international standards. I mean, it is quite astonishing that we are now considering the UN smuggling protocol as an example of a good standard, but unfortunately, this has become the case. It is very, very, very important that lucrative intent and some form of exploitative intention are part of the configuration of the baseline crime, and that everything else becomes decriminalized, including this crime of instigation, public instigation. That's absolutely horrible. I mean, it is good that already that the Council is considering this as a step too far, and probably this is not going to go into the final version of the directive, but in any event, it is of crucial importance that there is actual full alignment with the UN smuggling protocol, because otherwise we're going to be giving Europol a function that doesn't match the actual definition on the crime of facilitation, and that incoherence actually leads to an undue expansion of police powers that is going to further curtail the fundamental rights of civil society. The second is that there should be coherence with other protection-oriented EU law instruments. So, for instance, the Directive on Victim Rights should be applicable in this realm. So, if we are considering smuggling a crime, the victims of that conduct should be treated as such, not as co-perpetrators, and they should benefit from the protections that are inscribed in the relevant instruments. And this goes, for instance, not just for those in particularly vulnerable situations like trafficking victims of minors, but also generally all those that have been subjected to the crime of smuggling, if smuggling is indeed configured as a crime, should be protected under the victim rights instruments under EU law. The third is that fundamental rights safeguards should take binding form in the operative part of the text and should be effective, both in law and in practice. So they should be accessible and they should be exercisable, both again in law and in practice, not just on paper, but actually in real fact. There should also be a clear demarcation of facilitation offences. And I feel that I'm running in circles, but just to be very, very sure, this lucrative intent should be the baseline once again. So everything that doesn't incorporate this, like these aggravated forms of crimes that have been proposed, all of that should go. Because, for instance, there's one part where exposure to serious harm attaches higher penalties and lucrative intent is not necessary. This means all search and rescue activity could, I don't know if inadvertently or willingly, be caught in the net of criminalization, and this would go against the duty to render assistance under international law and the right to life of those concerned. So decriminalization of conduct that lacks criminal lucrative intent is really the key and main action that I think we should be pushing for the European Parliament, so that there is indeed an improvement from the current text rather than a regression. And we do not make things worse, but make them better. investigative police powers and preventive measures, as well as the penalty framework, and I'm sure Mary after me is going to be looking into this, should be proportionate. So the current provision, I think it's Article 16, that allows for special investigative measures like wiretapping and confiscation of vehicles, including search and rescue vessels, for example. I mean, all of this is completely disproportionate. Also, if we consider that there is an utter absence of procedural safeguards. So there isn't a provision that says this is the process through which people are going to be heard, are going to provide their reasons for their actions. And like this, some of the preventive measures are not going to be adopted, or some of the special investigative powers are not going to be launched. Here, although there can be a complete detachment from organized crime, Article 16 of the proposed draft reform appears to be providing very invasive investigative powers to police, prosecutors, and others that can in themselves amount to serious violations of fundamental rights. So this needs to be revisited, and it could be resolved if there is indeed full alignment with the smuggling definition at the international level, and if the standard adopted is finally criminal lucrative intent. Both of these concerns could be addressed if these two proposals are taken on board. And I think finally, it's very important that we preserve civic space. It's been shrinking for a number of years due to a plethora of different factors. And this requires that there are explicitly exonerating clauses so that actions that protect, promote, or fulfill the rights of the country nationals are excluded from the realm of criminalization. I think the Kinsa ruling is a timid but good step in the right direction. Timid because it only addresses the very specific situation of a mother or supposedly a father traveling with their own minor children for which they have effective care. I think that is the formulation used by the court. And on the basis of the right to family life and the best interest of the child, this is behavior that the court considered doesn't pertain within the scope of the behavior to be criminalized. But what about, as Julia was saying, pilots of vessels? What about people who self-smuggle themselves, as the Italian prosecutors would have it? What about humanitarian assistance or human rights defenders providing any form of solidarity-based support to those in need? All of this would have been, I think, so the court should and could have taken as the center of gravity of its decision Article 31 of the Refugee Convention that exonerates from penalties those that access European territory on an irregular basis, and presumably also those that assist in that action. But they haven't taken that pathway, right? So the basis for exoneration here is family life and best interest of the child. So the question remains, what happens when these two specific rights are not engaged? Are we supposed to take a similar approach when other fundamental rights are on the line? The right to life, the right to dignity, the right to protection from torture and refoulement, or the rights to political assembly, freedom of speech, etc. These are questions that the Kinsa ruling doesn't address, and I think by analogy should be pushed in the same direction when the legislative reform is discussed between the co-legislators.
Okay, thank you very much, Violeta. Thank you for pointing out your concerns, but also giving some very concrete recommendations, what must be in the new Facilitation Directive. And perhaps we have some minutes at the end to discuss if the draft proposal of the rapporteur, if it already takes up some of these recommendations. Again, if you have questions to Violeta, please write them in the chat and we try to answer them later on. But now we are moving to our third panelist, Mary Lawlor. Mary, you have been appointed as UN Special Rapporteur on Human Rights Defenders in 2020, and I think we can really say it has been a hard time because the shrinking space is a huge, huge problem we have all over the globe. So we have a lot of work on the table. Nevertheless, you also took some time to publish a position paper on this draft Facilitation Directive. Why has the US people smuggling legislation been a concern for you during your mandate? You have to turn on your mic, please.
Yeah. Sorry about that, everybody. So, as you said, I took up the mandate 5 years ago, and may I say how glad I am to be part of this discussion and event, because it is a subject, the protection of human rights defenders exercising their right to defend the rights of others, and particularly a priority for me has been retaliation against people for solidarity with migrants, refugees, and asylum seekers. It's something I've been doing for the last 5 years as part of the work. As we all know, it's a huge issue around the world. And in the EU, the retaliation has been going on for a long time. And it's mainly taken, as we've heard, the form of criminalization. Although we do see other attacks, for example, the bombing of the offices of Kisa in Cyprus in January 24. By criminalization, I mean the conflation of peaceful activism in defense of human rights with criminal activity, either through criminal proceedings or public smears, and they often go hand in hand. And most of the criminalization is for people smuggling offences, and the domestic legislation is based on the EU's framework laid out in the facilitators package. We've heard about Greece, and I did an official investigation there in 2022 and focused on the issue. And I also did a report to the General Assembly on human rights defenders who are protecting the rights of refugees, migrants, and asylum seekers. But, you know, there are examples of this in this, because we're talking about Europe, there are examples of this happening all over Europe. For example, in the case of Leva Robisco in Latvia, who's been on trial for more than 2 years and risked 2 years in prison for supporting people on the Latvian-Belarus border. Another example is, as we all know, the trial of the Juventa crew in Italy. And many of you will know that the investigations began against them in 2016. Their boat was seized in 2017, and it took until 2024 when the case was finally thrown out after the prosecutor asked for it to be dismissed. I think that's great. Just recently, we had two human rights volunteers who were arrested and charged in Bulgaria, and that case, they're charged with people smuggling, and that case is ongoing. But this is just the examples, but there are many more cases. And wherever people are acting in solidarity with migrants, refugees, and asylum seekers, there's a risk of this kind of thing happening. And that's why it's a priority for me. And it's also because I've seen such a huge shift from the time when I started in this work, where, you know, it was a good thing to help people. And now it seems it's such a bad thing.
Mm. Yeah, thank you very much, Mary, for that. So you have published a position paper on the draft Facilitation Directive of the Commission. Can you point out also your main concerns?
Yeah, well, there were, because, you know, my mandate is the protection of human rights defenders, people who are defending the rights of others peacefully. We stuck to the three main issues for human rights defenders. And the first issue was the failure to include a binding humanitarian clause. We've heard reference to this part before in the meeting. We believe this is needed to make sure that acts aimed at upholding the human rights of migrants and asylum seekers will no longer be criminalized. The clause that was included in the 2002 facilitators package but it was optional, and the Commission have proposed relegating this to the recitals for the new directive. So the Commission's proposal would also keep the door open for criminalisation. It fails to align the definition of smuggling with international standards. I know I'm repeating what some of you have already said, which require a profit motive for action to be considered criminal. Although the Commission made this alignment, at the same time, it included an exception where it isn't necessary, if there is a likelihood of causing serious harm. And this isn't in line, as we've heard, with international standards, and it's not in line with what the Commission say they are trying to do with the reform. And the second issue is the creation of a new offence of public instigation of illegal entry, transit and stay in the European Union. We fear that if this is included, it certainly would be used against human rights defenders. And the only justification provided for the new offence is that it is necessary to discourage the working methods of smugglers. It does not require a profit motive. It does not meet the standard of legal certainty and must be removed. And the third issue is the Commissioner mandating the use of special investigative tools without including any human rights safeguards. Through this, we seem to be seeing the legislation of bad practice, which we're already seeing in the bloc. And one of the things that was revealed in the Violeta trial was the extent to which the Italian authorities had used surveillance and investigations built to combat the mafia. It was a complete waste of resources and left the Violeta ship rusting in port for years while people were dying in the Mediterranean. So after the Commission made its proposal, these were the things we were drawing attention to. We were hoping for positive action from Member States in the Council, but the Council's position is also very problematic. The positive is that they are suggesting the removal of public instigation, but there are a couple of major new issues. The Council included a reference to the humanitarian clause in the recitals, as the Commission did, but there is no reference to the clause in the operative part of the text. The Council even undermined the humanitarian clause by adding a recital directly connected to it, in which their proposal states that Member States are free to adopt a broader incrimination than what is set out in the directive. And we all see all the time what these kind of loose powers that are given end up doing to people. And the Commission redefines the profit motive as something that states can decide whether to include or not. And there are no safeguards have been included concerning the use of special investigative tools. The Commission's proposal here was left untouched. And they are suggesting broadening the problematic concept of instrumentalization of migrants, which was already included in the Commission's proposal. A recital is included to say that humanitarian assistance should not be considered as instrumentalization, but only where there is no aim to destabilize the Union or a member state. And that's not enough of a safeguard for defenders. So these are the issues we're hoping Parliament will address, and basically we will do whatever we can, and otherwise, human rights defenders and the migrants they're trying to protect risk being locked into this repressive legislative environment for about another 20 years or so. Thank you.